In the immediate aftermath of the Civil War, African Americans went from having the status of being property themselves to becoming property owners. Families would do incredibly heroic things because land ownership to them represented the ticket to the American dream. My name is Thomas Mitchell, and I am a property law scholar. There's, unfortunately, the sad fact that as more African American families became landowners, more of them became a threat to a society that was structured along white supremacy lines. There have been a variety of legal mechanisms that have been used to displace African Americans from their land. The process that I focus on is a property law called the law of partition. So my best example of this is Hilton Head Island in South Carolina. What held Hilton Head Island back, so to speak, was that it was not connected to the mainland. So it was remote. And that was the case until the early 1950s when the state of South Carolina funded a bridge project. And immediately you had a number of real estate developers. They could see the potential of Hilton Head. And at the time in the early 1950s, the majority of Hilton Head Island was owned by African American families. And these real estate developers and speculators just started preying upon one family after another. And one of the major tools they used was the law of partition. At the time the African American families first acquired ownership of this land after the Civil War, the overwhelming percentage of them did not have any practical access to lawyers. So if you own property and you don't make a will, your property will be transferred to your successors under a tenancy in common. If those who then acquire the property as a result of intestacy, they don't make wills, their property transfers by intestacy. So what you have is property, for example, that might have been owned, say, in 1870 by a mother and father, and several generations later, it's not unusual to then have 30, 100, 500 of these heirs or these tenants in common. And these real estate developers, they use this because all you have to do to force a sale of the property is pick off one family member who was one of the common owners. And it doesn't matter if you have a 1% interest. So real estate speculator comes knocking on their door, offers them $500. Oftentimes a family member who was least connected to the land or the property. But what they certainly didn't know, many of these extended family members, was that they were putting in a chain of events that would ultimately result in their families being dispossessed of that property and usually dispossessed of a significant percentage of their real estate wealth, given that these sales tend not to produce anything approaching the market value of the property. We are essentially still experiencing this current vestige of Jim Crow. There had been a narrative when I began this work that nothing could be done, that it was almost the natural condition of African Americans to be preyed upon, to be these defenseless victims. No, I thought it was important to establish that the law could actually work for these families. And so our idea was to submit a model state statute to the Uniform Law Commission proposing significant reforms to this law of partition. The Uniform Partition of Heirs Property Act has now been enacted into law in 17 states, as well as the United States Virgin Islands. I hope at the end of the day that my work will enable families and communities that have often been relegated to the margins of our society to live in an America where they can fully experience and vindicate both their civil rights and their economic rights, such that they can fully experience the American dream.